Here's a puzzle. You're named in a contract. The contract says you should benefit, but you had nothing to do with signing it. Can you sue to enforce it? For centuries in English law, the answer was an emphatic no. That's the doctrine of privity. In this video, we're building up the full picture of privity and third-party rights in 5 steps. The core rule, its relationship to consideration, the narrow common law escape route, the 1999 Act that changed everything, and the practical limits that still apply today. The Privity Rule says only a party to a contract can sue on it or be bound by it. A third party, someone entirely outside the agreement, has no rights under it, even if the contract was made expressly for their benefit. The rule was stated clearly in Tweddle v. Atkinson in 1861, where a son could not enforce a contract made between his father and his future father-in-law, even though the contract named him and promised him a payment. The House of Lords confirmed the rule in Dunlop v. Selfridge in 1915, where Dunlop tried to enforce a resale price term against Selfridge, and failed because Dunlop was not a party to the contract between Selfridge and the wholesaler. The rule can feel harsh. The person most directly affected by a contract has no legal remedy if it is broken. It is worth separating 2 related but distinct rules. Privity asks, are you a party to this contract? Consideration asks, did you provide something of value to support the promise? In Tweddle v. Atkinson, the son failed on both counts. He was not a party and he had given no consideration. But these are separate hurdles. You could imagine a situation where someone is a party but gave no consideration, or where someone gave consideration but is not a party. English law requires both. You must be a party and, generally, have provided consideration to enforce a contractual promise. The cleaner authority for the consideration point is Curry v. Misa, or the rule that consideration must move from the promisee. Stilk v. Myrick concerns a different issue, namely whether pre-existing duties can constitute consideration. Before Parliament acted, the courts developed some limited ways around the Privity Rule. The most significant is agency. If one party contracts as agent for a disclosed or undisclosed principal, the principal can sue and be sued on that contract. Collateral contracts offer another narrow route. A separate contract can exist alongside the main one, creating a direct obligation between parties who are not in the main contract, and the benefit of a contract, a contractual right, can be assigned to a third party, so that the third party steps into the shoes of the original promisee. Crucially though, the burden of a contract cannot be transferred without the other party's consent. These routes are real, but they are indirect, technical, and heavily dependent on the facts. They do not give a clean right to a stranger to enforce a term. The Contracts, Rights of Third Parties, Act 1999 is the major reform. Under Section 1, a third party can enforce a term of a contract in 2 situations. First, where the contract expressly provides that they may. Second, where a term purports to confer a benefit on them. Unless, on a proper construction of the contract, it is clear that the parties did not intend the term to be enforceable by the third party. This second limb is the more commonly litigated one. The question is whether the contracting parties intended to give the third party an enforceable right, rather than merely conferring an incidental benefit. The third party must also be identified, either by name, as a member of a class, or by a description, at the time the contract is made. So a contract that says, this clause benefits employees of X Limited is sufficient. A vague benefit to the public at large is not. When a third party can enforce under the 1999 Act, their position mirrors that of a party in important respects. They can take advantage of any exclusion or limitation clause in the contract that would have protected them. The promisor can raise against the third party any defense or set-off that would have been available against the original promisee under the contract. However, the parties who made the contract retain a right to vary or rescind it, unless the third party has assented to the term or has relied on it and the promisor knew of that reliance. Once one of those conditions is met, the third party's right is effectively crystallized and cannot be taken away without their consent. The Act is powerful but not unlimited. Critically, it only allows a third party to enforce a benefit. It does not impose contractual obligations or burdens on them. An employer cannot use the act to bind an employee to a term in a contract the employee never signed. Section 6 of the Act excludes certain contracts of carriage of goods by sea from most of its provisions, reflecting the specialized regime under the Carriage of Goods by Sea Act 1992, and the Act sits alongside, not instead of, the common law exceptions. Agency, assignment, and collateral contracts all remain available. In practice, sophisticated commercial contracts frequently include explicit clauses, either invoking the Act or excluding it. A party drafting a contract should always consider whether third-party enforceability is intended and say so clearly. Now a check on your understanding. A contract between A and B states, this clause is for the benefit of C. C later sues B when B fails to perform. Which is correct? A. No. C is not a party and privity bars all claims. B. Yes. The contract expressly confers a benefit on CC, only if C provided consideration to A or B. D. Only if C is a close relative of A or B. The answer is B. Under Section 1, Subsection 1, Paragraph A of the 1999 Act, a third party may enforce a term where the contract expressly provides that they may, and the clause here does exactly that. Consideration and family relationship are irrelevant under the Act. So, the Privity Rule, confirmed in Dunlop v. Selfridge, bars strangers to a contract from suing on it. The 1999 Act carves out a significant exception where the contract expressly or impliedly intends to benefit an identified third party. But the Act only grants rights, never burdens, and the parties retain control unless and until the third party crystallizes their position by assent or reliance. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.